All right, so we are True Property Inspections. We also have True Group. And we have been in business for over 2 decades. Our roofing side of our company has actually been in business since the 1950s, but we have 2 decades of experience in water intrusion, moisture control, and construction defect correction. So we're excited to talk with you today about SIRS Milestone. And we partner with some partners and engineering firms who we'll talk about in a minute.
And thank you to True Property for having us here today. It's always a pleasure working with you guys, and hopefully we can give some good information out. And we love being able to share the stage with you, so to speak, so that you can give some of the on-the-ground advice that, frankly, I am far from qualified to provide because I don't really wear hard hats except for the gel that's in my hair. So thank you for your time today, and I'm going to go ahead and share the screen because I know you guys had some things you wanted to share before we actually get into my portion of the presentation. I don't know if any of it is what Rachel already addressed or what, but you guys, if there's anything that you wanted to share on these particular slides, feel free, and we'll go from there once you're comfortable that we're ready to move on.
Yeah, Jim, do you want to address what's on the slide there? And I failed to introduce Jim Ilardi, so we have Rachel and Jim with us today.
Great. My name is Jim Ilardi. I'm the CEO and founder of both True Property Inspections and True Group. The interesting part of who we are and how we're able to provide the service is that we started out with doing the work. As a result, we've taken apart multiple projects over the span of, well, I have to say about 50 years. I am that old. And as a result, we're able to accurately understand what's going on when we do an inspection. So True Property Inspection does partners with engineer firms. We specialize in water intrusion issues and obviously GC work as well. So we have a unique understanding when we go to do an SIRS. We're able to accurately identify the pieces and parts of a building and how much life expectancy you can expect for the near future, whether it be 10 or 20 years down the line. A lot of times these type of inspections are done on a scale. So if you have a roof that's shingled, they look up the shingle and they're expecting it to last 15 years. So they don't, and you have a 5-year-old roof, then they're going to say it lasts 10 more years. We inspect, and if it's properly put on, it may be 20 years, or maybe you may have another 5 years and not the 15 years because it was poorly put on. So we address each component, and we accurately understand how much more life expectancy you have. The other part of our company is True Group. We do things with a waterproofing understanding. When we remove and replace, these different components, the end product is waterproof. So you have a good life expectancy with the work that we do when we do the GC work. It's important to know that because most of the problems that we're finding structurally originate from water intrusion issues. So one of the unique things about this SIRS and Milestone, I know it seems like it's a burden, but it actually isn't. If it's performed properly, it will catch things when they're small, and as a result, you won't get into these big structural issues. But the key to everything is waterproofing and bringing in a product that lasts the time. I'm going to turn it back over. Alan?
Do you want to go through what these certifications that you have mean? Because there's like 82 of them that you have right now. Do you want to go through briefly what they mean and how it gets started?
Yeah. So I'm not alone in the certifications. These actually all of my certifications. We have many more within the company, but so these are the key ones. So general contractor, I can build high rises. I do fix them. But we don't build them. A roofing contractor, you name it, whether it's a shingle, tile, metal, any type of flat, we find reasonable ways of fixing it. Mold remediation, that's the highest certification you can get in water damage or mold remediation. We've salvaged projects that was set to be torn down. We were able to fix them and certify them at the end. CMCC, that's kind of the thing that we highlight the most. It all has to do with water intrusion and water management. I'm one of 3 in the state of Florida that has this certification, and one of 10 in the United States. It's the highest certification you can obtain when it comes to building envelope issues. It's not just the stopping water from getting in, but once it gets in, how to manage it. So it's quite comprehensive, very scientific. It's how moisture and material respond to each other. And we've got quite a bit of that. So there are 3 key principles, and all 3 of them working against us in Florida. Hot goes to cold. We've got a lot of hot air, and we try to keep it cool inside. And then high pressure goes to low pressure. And I say that because most places, other than businesses, have fans in the bathroom and hoods over the kitchen, stove. And once you turn them on, you're sucking air out of the building, and that makeup air has to come from somewhere, and it usually comes from hot, dirty areas. And then the last one is, well, I'm missing it. Wet goes to dry. So we have high relative humidity outside, and we try to keep low relative humidity inside. So all 3 scientific pieces are trying to find its way inside. So, the envelope of your building, the roof on down, windows, doors, any cracks, it's all trying to have the outside work its way inside. And so waterproofing a building and drying it in properly is the single most important investment you can make on a structure.
All right. Well, that's a lot more information than I'd be capable of giving. So thank you, Jim. I think that's really helpful as a starting point on what we're going to talk about today. But first, I'm going to do what I do best and talk about myself real quick. Kaye Bender Rembaum's a law firm that's been in practice since the 1990s. All we really do is represent condos, HOAs, co-ops, and other community associations. I also mediate disputes involving these communities. But we've got 20 attorneys, 7 of whom are board certified in community association law, 1 of whom is board certified in construction law. So if you have these issues coming up that you're dealing with pretty much anything, but specifically what we're here to talk about today, where you need someone to review contracts pertaining to these reserve studies and inspections, if you need someone to help out with the legality of a dispute with maybe a developer, where there's a construction defect that's located because of one of these studies. It's probably too late at that point because it'll be 30 years after the building was created. But bottom line, whatever a community association needs, we're here to help out. We've got offices throughout the state. I'm in Orlando managing the office here. We've got an office in Tampa. Our main office is in Pompano Beach. We've got another in Palm Beach County. So really statewide, if anything comes up with a community association, feel free to reach out. I've got my email address right in my little name thing here. Feel free to email me anytime, but you'll also have the contact information for the firm on the slides after the show is done. So getting right into it, because we don't have a ton of time, but we do have a ton of information to get through. What are reserves? What the heck are we talking about when we say structural integrity reserve study? That is one of the 2 major topics we're here to talk about today. So the first thing that I thought was important to talk about, what is a reserve? It's essentially money that you're putting aside because you think that an asset will eventually have to be either replaced or repaired, and it's not something you're going to repair once a year, for example. So we're talking about, now these statutory requirements already existed before all of the major issues that we're going to talk about, before this debacle started. Okay, roof replacement, building painting, pavement resurfacing, and anything else that has a deferred maintenance expense or replacement cost that exceeds $10,000. What do we mean by deferred maintenance? Basically, if it's not something you're going to do once a year, that's deferred. You're deferring it until the maintenance is necessary. Replacement cost, I hope, is pretty clear, but you're actually replacing it. So you might maintain the roof, you might just go ahead and patch a couple spots in the roof, or you might completely redo it. Those are the two different options we're talking about here between deferred maintenance, which is just we're maintaining it, we're doing repair work, so to speak, versus replacement cost. But the reserve is the money you put aside in order to be able to pay for that deferred maintenance or that replacement cost when it's needed. So keep in mind, these are not things we're doing every year. When you talk about a roof, Jim mentioned, you might be looking at a couple years, you might be looking at a couple decades before there's any maintenance that's needed on that roof. We're going to set that money aside so that when that maintenance is required, we have the money to do the work so that we don't end up in a situation. And I'm not going to get deep into what actually caused the building collapse in Surfside a couple years ago, but that's how all of this started. Was a bunch of politicians made a presumption that this was a result, that building collapse in Surfside and the death, unfortunately, of I think it's 98 people was caused by a failure of the association to properly maintain the building. We now think that it was based on a structural defect, that the pool and all of that was constructed poorly, and that resulted in the building collapse. But the bottom line is the legislature has put in place a lot of things that an association never had to do before that are now going to be mandatory for every condominium of a certain height in Florida. We'll talk about what those specific requirements are in a minute. But bottom line, that's why we're here today, because some politicians thought it was a good idea to force the association to reserve funds to make sure you have it for structural components of your building. So now that we know what a reserve is, how do we figure out what they are? Well, one is you get a reserve study, someone will tell you what they are. So that's one of the things we're here to talk about today. The alternative for these things that are not required to be reserved under the statute or are not mandatorily reserved without the right to waive those reserves. And that's basically everything that I just mentioned and anything else that I'm not going to mention in a minute. But the way you compute those reserves is you essentially take what is it going to cost to do that repair, to do that replacement down the road. You figure out how many estimated years of useful life that asset has left. And you really just divide one number into the other. And that's how you come up with your figure. Now, a reserve study is a useful tool to figure out what that dollar figure looks like rather than guesswork. Okay, if you're having work done, yeah, okay, you can have your vendor that's doing the work now tell you how much longer that work is going to last and when that new maintenance is going to be needed. But the general guideline is every 3 to 5 years or so, you're going to want to have another reserve study done to make sure that you're still on track to save the right amount. Because we all know what inflation looks like in recent years. It's entirely feasible that the amount that you were given by that vendor, even through a formal reserve study, is going to be no longer accurate 5-7 years from now because inflation kicks in. So you can either adjust for inflation, which is significantly less accurate, or you can get a reserve study done that shows you exactly what you should be putting aside every year. So just a quick example, if you've got a roof that costs $100,000 to repair, and you think that that's going to happen every 10 years, that repair, you're putting away 10 grand a year. And in year 3, year 5, whatever it may be, you have another reserve study done. You find out, nope, it's not going to be $100,000 to fix this. It's actually going to be $150,000. Okay. Well, for the 5 years we've put away 10 grand a year, we've got 50 grand in the bank. Now we need another 100. So over the course of the next 5 years, we're going to have to save $100,000 divided by 5, not divided by 10. So that's really how you're doing the calculation. That's very simplistic. That is the straight line method of doing that calculation. The alternative method is called pooling. Now we'll get into that later, but essentially what it means is you're putting away enough money each year to make sure that there's enough money to fix each asset in that pool or replace each asset in that pool when you expect that particular component to fail. So you're technically putting away less money every year to make sure that you have enough money set aside in that pool for all of the assets that are in that pool whenever each one is expected to fail. So moving forward, calculating an accurate life. I think, Jim, you'd probably be best to tackle this, but you know, you're going to look at what was done here. what is the quality of what was done? Jim, you want to step in?
Yes, sir. Thank you for that. Yeah, so workmanship is really important. So it boils down to the vendor. So you replaced your roof, a shingle roof, well put on. Actually, a shingle roof should last, even in Florida, 20 to 25 years. In fact, there are actually warranties out there that will allow you to buy a warranty, labor, material, and equipment for up to 30 years. That's well worth the investment, right? Because now you can put 1/30th away each year rather than 1/15th away. So the difference may be nominal, and we'll go into the next slide to give you an understanding of that. Quality material, that goes along with the workmanship. Good workmanship, good material equals a good investment. So I want to talk about warranties because a lot of people don't have an accurate understanding of how warranties work. A prorated warranty is like a battery that you buy for your car. You buy it and it has a warranty. It has a 3-year warranty. Year 2 comes along, the amount of warranty that's left on that prorated may be 10 cents on the dollar, which means that you have to come up with 90% or 90 cents on a dollar. That's a prorated. A no dollar limit means that you buy that same battery and it has a full warranty for 3 years. That means year 1 is the same as year 3. 2 years, 11 months, and 29 days, you go to turn that battery in. Under warranty, you pay nothing to get that battery replaced. That's a no dollar limit. Then there's a third one, and a lot of you may have experienced this. We call it the taillight warranty. When the contractor leaves the property and the taillights disappear, so does your warranty. You try to call them back for a warranty issue, and no answer. And they just don't show up. So evaluating a vendor and the type of warranty that they're offering is extremely important for your reserves. So the next slide. Who has control of it? There you go. So this is kind of just an example of what it looks like. So if you have a shingle roof you're replacing, you have a 15-year warranty. And by the way, that does not mean that it's an NDL. It could be a prorated 15-year warranty. But let's say it's a fully NDL warranty. So if you have a roof that you're replacing and it's a 15-year warranty, it's going to cost you $66,500 a year. But if you get a good warranty, a good roof, now you have it 25 years. It costs you a little bit more, but the actual reserves going forward is only $44,000. And the same thing goes with painting versus waterproofing. And I can't tell you how much I talk about this when I do these kind of lunch and learns. It's important to put a little bit of extra money in. Don't pick just any contractor. You get 3 bids. Don't pick the lowest bid. Don't pick the highest either. But make sure you're getting your investment for the money that you're putting out there. So waterproofing is a lot more than just painting. I call painting coloring a building. All it is a thin membrane. By the way, it will look just about the same with a paint job versus waterproofing. It's just the amount of life you'll get out of that product. So when they just paint, things will disappear, but it's a very thin membrane. And as the seasons come along and the hot and the cold, the material will swell, it'll expand and contract. Eventually that thin membrane will fail and you'll start seeing those fissions and then the cracks, and then those turn into structural issues. Okay, Alan?
Appreciate that. Again, information I wouldn't have been able to share. So thank you for having us here to share the legal, but the practical is definitely all you guys. So let's get into step 1. We've got the milestone inspections. These are mandatory for certain communities. There are bills pending regarding these issues. We've got a 1-hour webinar that we've done in the past with Castle Group going through some of the changes that might be coming down the pike effective in July or October of this year. And that's available on our firm's website at kbrlegal.com under the resources tab. But the big one is that it would directly authorize a special assessment to fund loans or lines of credit that are intended for repairs that are required because of what pops up in one of these two reports. So I'm not going to go into a ton of depth regarding the upcoming statutes. I'm sure we'll do a legal update coming up in the next few months once we figure out what the governor actually signs, what gets vetoed. But that's one of the big ones that we think is coming down the pike sometime in the next few weeks. So bottom line, you know, the big change that we expect in Condo 3.0 is how it's been labeled, is that you probably will be able to fund these mandatory changes before you can go back and get the reserves established through special assessments that even if the declaration says you need a member vote, the legislature would say you don't. So this is something we've been pushing through for the last 2 years since all of this started, and I'm really happy to see that. I hope it's going to be adopted sometime in the next few months so that the association can do what it needs to do to not only get those actual reserves funded, but to get the studies themselves paid for that you're supposed to be paying potentially thousands of dollars to have addressed. So question one, do we even need a milestone inspection? I mentioned earlier, not every condo in Florida needs these studies. So hopefully if you're in the room, you've already found out and you've evaluated that the owner of a building 3 stories or more in height as determined by the Florida Building Code that is subject in whole or in part to a residential condo or co-op form of ownership is the only type of community that needs to comply with these milestone inspection requirements. So if you are in a mixed use, you're in a condo hotel, the portion that's residential is subject to this. The portion that is commercial, meaning the hotel owner, the other portions of the building, even if it is the same building, none of that is going to be subject to this milestone inspection report. So it's really important that you have your attorney evaluate and look through, which portions of this building are actually subject to the condo form of ownership and which ones are we responsible for maintaining. Because something that the association is not responsible for maintaining, that condominium association is not responsible generally for getting this milestone inspection report to include. That doesn't mean it doesn't need to be inspected and addressed properly. There are local requirements that'll supersede and say, well, I don't care. Every building needs to have this done once it reaches a certain age. But when we're talking about these particular restrictions, just understand each building that qualifies under what we're describing in this slide is going to have this milestone inspection done. Purely commercial buildings are completely excluded. So anything that's lower than 3 stories, meaning 2 stories, according to the building code, is commercial in nature, or any portion that is commercial in nature. Generally, your residential association won't have to comply, or will have to comply. The commercial won't. Okay, moving on. What the heck is a milestone inspection? It's essentially a structural inspection of the building components, and it's generally going to be load-bearing elements and primary structural members and structural systems that are defined by statute, which no longer includes walls. Okay, what we're doing is physically taking a look at the building, and this is phase 1 of potentially 2. Okay, it's literally taking a look at the building and saying, does everything look safe? Is it structurally sound? That's the entire phase 1. Now, it does require that someone qualified to do that inspection actually perform it. It needs to be done by an architect, an engineer, and these are 2 licensed individuals, or a team with one of these acting as the registered design professional that's responsible for the reports and the work, and they're the one that's going to sign off and issue and seal the reports themselves. Now, I know that there's been already a question, does True Group and does True Inspections, does True Property use one of these, or do they have someone in-house that's licensed? The first slide of this entire presentation clarified they're using an engineer that's licensed as the team lead for all of these inspections. So there shouldn't be a question as to whether they're allowed or able to do these types of inspections, produce the reports, and have them be statutorily compliant. The purpose, moving on back into the substance here, the purpose of this is to make sure that the building is safe. That's pretty much it. Is the structure of the building safe for people to actually reside there? That's the whole purpose of this milestone inspection report. It's to avoid situations where someone should have known that there was a problem, but no one bothered to inspect the building over the last 35 years. Okay. What is this not going to address? It's not determining whether the condition is in compliance with the building or fire safety code. Okay, that doesn't mean that issues with those codes won't be pointed out in advance, but that's not the purpose. It's not to identify surface imperfections, unless those surface imperfections are likely to lead to a structural deficiency. Okay, or substantial structural deterioration is actually the term that's used in the statute. Okay, unless those imperfections are actually causing a structural issue, they're generally not going to be noted, or at least they're not going to be something that the investigation is going to tell you need to go to the next phase, unless they think that there's a problem there. So what is substantial structural deterioration that's used in the previous slide and in the statute? It's essentially the visual inspection is the only thing that's required unless one of these structural components is expected to have a major problem. It's substantial structural distress or substantial structural weakness that negatively affects the building's general structural condition and integrity. In other words, do we have the risk that the structure of this building is compromised based on what we're physically seeing when we do the visual inspection? Jim, I know you've got a bunch of experience and examples here. You want to jump back in and explain, what some of these problems are and why they're a structural issue?
Great, thank you for that. So, I've seen a lot of properties over the years. Again, I've been doing this about 45, 50 years now. So I get to see the building being taken apart, and something that's big in somebody's eyes may be small in my eyes, because I kind of know what type of product is being affected and the cause or the effect of the water intrusion. And then I see other areas where there's a small area. It looks kind of benign, but when we start pulling it apart, we recognize that there's substantial structural deficiencies there. I'm going to go through these slides a little bit. You can see a small, well, it started on the left side. There was a small hole that, from the ground, you really couldn't see much of it. We did a little bit of inspection on it. And then we found a little bit of wood rot there, right? But that was only the beginning of it. On the right slide, you see that little hole blown up. Next slide, if you could, Ellen.
If this would work, I would. There you go.
There you go. So this is what we found. So that little bit became a lot of bit. As you can see, that looks substantial, right? So water starts high and it goes low. It'll find the lowest point, and that's where it tends to congregate or wick. And so water is like a chain. Once it gets wet, it starts forming more chains and working its way up. But it may come up top, but the structural deficiency will be at the bottom, most likely. And that's what we find a lot of. I love telling the story. I'm walking through a property, a pretty large property, about 450 units. And so I'm walking with the CAM, and at the bequest of the board, they're looking to paint the property. And so we're walking around, and I'm kind of preparing them that, waterproofing would be more appropriate, because I'm seeing some deficiencies, right? And not to his eye, but to mine. And so he drags me over to a 3-story breezeway with tile roof on top, very heavy roof. And we're looking up the wall, the side of the building, 3 stories high. And he points out to this bubble or bow in the wall. And so about a story and a half up, there is this bubble that's protruding out about 1.5 feet, 2 feet. So I casually asked him to step back, and I described what I was seeing. That had no structural integrity left, none. I convinced him, but we convinced him that we needed to shore it up immediately. And that day we brought a team over, and we 4x4, 3 stories high, we shored it up. We then gave him a bid on repairing it. We pulled it apart. The only thing that was holding up the 3 stories was the stucco. Once we cut the stucco away, we did not need any tools. So does anybody know what follows water? Termites. So between the wood rot and the termites, it was gone. And yet there was very little, other than the bow, there was really no really sure sign of what was going on, except if you look about 2.5 stories high, you saw this little opening, and that's where the water was coming in. So you never know. You have to have a keen eye to understand water and material and the effects of it. Thank you, Alan. Turn it back to you.
All right. So the next question, now we know what a milestone inspection report is. We know what communities are subject to it. When do we need it? Well, basically 30 years after the certificate of occupancy was issued is when you need it. If you're subject to it and you're subject in whole or in part to the condo or co-op form of ownership, you need to have it done by December 31st of the year in which the building reaches 30 years from the date the first certificate of occupancy for the building was issued, and then every 10 years after you get that done. That does not necessarily mean that you're doing it immediately, okay? So this is, yes, it's a new requirement. It doesn't mean you're doing it today just because it now exists. If the building hasn't reached 30 years of age yet, not something you need to do yet. If the building reached 30 years of age before July 1st of 2022, you have to have this done by the end of this year, 2024. If that date of the certificate of occupancy was 30 years after July 1st, 2022, but before the end of this year, you have until the end of next year. And obviously, if the date is later, you have until 30 years from that date. Now, if you can't figure out what the date is because it's 30 years ago and we weren't keeping very many digital records at that time, you basically have to do it. I don't know that it's in this slide, but you would go by the date the first certificate of occupancy was issued in the building, or the date that the building official has on record for the first time that the building was occupied. It's 30 years from that date. If the building records include a specific certificate of occupancy for the building, you need to go by that CO. If this report was already done within the last 5 years and meets all of the requirements of the statute, you can use that inspection in place of the phase 1 visual inspection portion of a structural integrity reserve study or of a milestone inspection report that would otherwise need to be done within these other years. The date where you're going from 10 years from the date of the last inspection, keep in mind, if you did it 5 years ago and you're able to use that report for this purpose, you're going to be 10 years from that 5 years ago. So you're going to need this again in 5 years. The local enforcement agency can shift from a 30-year timeline to 25 years. This used to be where every community or condo that's subject to this that was located within a certain proximity to salt water or any water was required to have this done within 25 years. I think it was proximity to the shoreline. Now the local enforcement agency is allowed to make the decision that any building that is within a certain proximity to salt water, which is really the only corrosive portion of the water, not just being close to the intercoastal, for example, but anything close to, depending on what's in the intercoastal, but anything that's within a certain proximity of salt water, the local enforcement agency can say, well, the statute says 30 years, but we're going to say 25 years from the date of certificate of occupancy. Now, that would require that the local enforcement agency send something to you generally. It's not just going to be, well, everyone located within this location, this county, this city, whatever it is going to have to comply with these different requirements. But it might be, so just be careful. Whether that local enforcement agency is obligated to provide notice or not, that doesn't mean they will, and they'll still try and hold you accountable. Just make sure that your attorney is looking into locally for you. Is this something that the local enforcement agency requires if you're anywhere near the shoreline or saltwater? That timeline that's been established for when you need to get this done could, when I say could, I mean may be extended. And that's the initial date, not the 10-year date. But if you've entered into a contract with a vendor that is qualified to perform this work and they're just not able to get out to you before that deadline hits. Okay, so for example, if your due date is December 31st, 2024, and that vendor, you weren't able to find another vendor, by the way, but that vendor isn't able to get to you until February 2025. The local enforcement agency has authority, but not the requirement to extend that deadline. So do your best. I mean, if your deadline is December 31st, 2024, it's time to get this done now. Because I am hearing some of the vendors that are doing this work are several months out, and I would anticipate that by August, you're already going to be too late to get it done this year. Not only because there are so many communities that need it done by this year, but because there are some that are doing it early to make sure that they just knock this out and they're done with it, or that just want to know what are the structural problems that might occur or might exist in our building. We talked about the local enforcement agency may accept a previous inspection report if it substantially complies with the requirements of the statute. You still need to comply with unit owner notice requirements. So we haven't gone through those yet. We will later, but it's essentially you need to give notice and a copy potentially of every one of these reports, the milestone inspection report and the SIRS report, to your members. Now you can post it on your website if you have one, etc. But you need to let the members know what the problems with the building are. That was part of the problem allegedly in Surfside, was that the members didn't understand what the problem was. They were just being asked for money to cure problems with the property, but there wasn't enough disclosure as to what those problems were. Whether that's accurate or not, I personally don't know, but that's the allegation that I've heard. As the justification for this requirement. I think that disclosure is a good idea anyway, because personally, if I was living in a condo, I'd sure as heck want to know if there's a potential structural issue with my building and I'm on floor 15. That's definitely something I want to know about in advance. The inspection is deemed to be a milestone inspection if the local enforcement agency essentially says so. So even if it wasn't a milestone inspection in name, it can be treated as one, is what this is saying. If the previous inspection is accepted, again, you move forward your 10-year date from the date that that report was issued. Mixed use and condo hotels must be arranged by the residential condo association. Keep in mind, I mentioned earlier, and any owner of any portion of the building that is not subject to the condo or co-op form of ownership. So if any portion of your building is subject to this, the condo association is only responsible for the assets and the portions of the community that the condo association is responsible for maintaining, repairing, replacing. That doesn't mean that the corporate owner, the hotel owner, et cetera, whatever it's labeled as in your community, is not subject to this requirement as well. It's intended to make sure the entire building is protected. The association and any owner of a portion of the building that not subject to these forms of ownership are responsible for ensuring compliance with these requirements. So the association is not responsible for ensuring that the condo owner, I'm sorry, the hotel owner is actually doing what it's supposed to do. It's responsible for its portion of having this inspection performed, having the reporting done, having the notice sent out to the members, etc. Not the portion for which the other owner, the hotel owner, is actually responsible. The association is also responsible for all costs associated with the portions of the building that it is actually responsible for maintaining. So again, not only the responsibility for having it done, but the cost is attributed to whoever's responsible for maintaining and repairing these particular assets. Okay, government notice. If a building must have a milestone inspection performed, the local enforcement agency must provide written notice of that requirement to the condominium association and to any owner of any other portions of the building, like we talked about the hotel owner, for example. That goes out by certified mail, return receipt requested, so there's some proof that someone actually got it. Thereafter, meaning after the association gets that notice, it needs to notify all of the unit owners of the required inspection within 14 days, not business days, but calendar days after the association gets this notice. You then have 180 days to complete phase 1 of the milestone inspection. Now, you can maybe argue that you're not required to have it yet, but the likelihood that that local enforcement agency is going to say, oh, okay, no problem, you can hold off for another 5 years. I would find that to be a low likelihood. And if you want to challenge that, you really need to probably file some sort of lawsuit that we don't have time to go into today, but to basically challenge the validity of that demand, which is really what this is, that you get your milestone inspection done. The other way of looking at it is you're going to have to do this anyway. You're probably going to want some kind of structural integrity review at some point to make sure your building is safe anyway. Why not just go ahead and comply early and then have to do it 10 years from now? The alternative, if you don't have to do it for at least another 10 years, yes, it might be worth arguing about whether or not you're required to do it right now. We talked about phase 1. We're going to look at habitable and non-habitable areas of the building. It's just a visual inspection. If the architect or engineer, whoever is overseeing this process, finds that there's no substantial structural deterioration to any of the building components for which this particular condominium or co-op is responsible, then there's no phase 2 inspection required. Phase 2 is where there was that type of deterioration, there was that type of potential issue, and that architect, engineer, or team is going to go in and physically, potentially even do destructive or non-destructive testing, meaning you might be pulling out chunks of the building to make sure that the structure is safe. It can be as extensive or limited as necessary to make sure that that report is actually going to accurately depict what the potential problems are and do the necessary review to recommend a program for fully assessing and repairing all of the damaged portions, all of that structural problem. In other words, phase 2 is here's what you got to fix and how we recommend you do it. If it's required, then within 180 days after submitting the phase 1 report, the architect or engineer that's doing the phase 2 must submit a phase 2 progress report. Even if all of the work hasn't been completed within that time, that report gets submitted to the local enforcement agency with a timeline of when you think all of that inspection will be completed. And this is largely going to be the responsibility of, the vendor you're using, but it's also the responsibility of the association to get the paperwork done in time, because it's not just the vendor that's going to potentially be fined and get in trouble and have other problems as a result of not doing this in time. So make sure that your attorney is involved here, that you're aware of what these deadlines are, and that you're making sure your vendor is complying with them. Once both of these are done, the architect or engineer submits a sealed copy of the inspection report with a separate summary of the material findings and recommendations. And that goes to everyone within the condo. And it pertains to not just the condo building, but again, any other owner or portion of a portion of the building that's not subject to the condo form of ownership. After that inspection is completed, whether it's just the phase 1 or if you needed the phase 2 when the phase 2 is also completed, within 45 days after receiving each one of those reports, the association needs to distribute a copy and the prepared summary, not the entire lengthy report, but the summary that investigator and then inspector is going to prepare, and send it to every member by U.S. mail or personal delivery, or if they've agreed to accept notices from the association via email or fax, you can produce it that way. You're going to also post a copy in a conspicuous location on the property and post a copy on the website or in whatever app you're using, if that's something that you're required to do and are actually doing. If you're required to do it to maintain a website, then please absolutely do. Let's see. There is, by the way, a similar reporting requirement for the structural integrity reserve studies. I know we're kind of getting late in the game already. I'm on slide 27 of 51, so I'm going to have to breeze through a little bit. I'm not going to cover everything that's in every slide, but we will go through the basics, and I want to try and leave some time at the end for Q&A. I've answered a couple of those questions already in the chat or in the Q&A portion in writing that you should be able to see. So the local government enforcement of repairs, basically the repairs need to be commenced after that report is done saying, hey, here's what you need to do. Those repairs need to be commenced, meaning not completed, but if you haven't started them within 1 year after receiving the report, you're going to be in trouble with the local enforcement agency. If proof of that is not provided to the local enforcement agency, local government reviews and determines whether the building is even safe for human occupancy, meaning that that local enforcement agency can shut the entire building down if you haven't started construction. They can do it in the interim if the report is that bad that it warrants it, but just understand whether it is mandatory or not under the report, the local enforcement agency can completely shut your building down if you don't get started on the work in time. So as soon as you get that report, you're going to want to meet with your attorney, start looking into potential vendors to perform the work, and start getting it done. The Florida Building Commission requirements, I'm not going to go through those because that's a requirement of what the government needs to actually do. You do need to get the work done is really the important part. It's not just, well, we have this report now, we're not going to do anything with it. It's, we have this report now and we have a legal obligation to do what this report tells us we should be doing. Moving on to structural integrity reserve studies. There is an exemption where you really don't need to reserve funds, even if it's an asset that the association is generally obligated to maintain. If the estimated useful life of that asset is more than 25 years, you don't have to reserve at all. So Jim mentioned that roof that's got a 25-year warranty. Understand there is a difference between estimated useful life and the warranty. Okay. If the estimated useful life is greater than 25 years, let's say it's a great roof and it's a 50-year estimated useful life, you're not going to reserve for that until it dips under that 25-year time frame. Okay, because why would you put money away for something you're not going to need, presumably, for another 50 years? It makes no sense. So the legislature got this one right, in my opinion. But you do need to reserve the amount of deferred maintenance expense required by the structural integrity reserve study for those items. So you may not be reserving for a complete replacement, but you might still be reserving for repairs that are going to be needed, let's say, every 10 years. And now that I'm starting to stutter because I'm speaking so quickly, I'm going to take a sip. I promise this is just water. The association can also adjust replacement reserve assessments annually to take into account inflation and estimates of the useful life, which we talked about earlier. So that is where you can basically say, well, this cost is going to go up over the time since we had this reserve study performed. If we wait for 10 years from now when we have our next milestone inspection report, that's not going to be done within the amount of time that we think is necessary to properly budget for this. So you can account for it either via separate inspections that you have every 3 to 5 years, like I said, or you can adjust for inflation, which is generally less accurate. If the actual replacement cost can't be determined because you have no idea what it's going to cost to maintain or replace this item, you also generally won't need to reserve for it. That doesn't mean you shouldn't do it anyway. You know, if it's not a required reserve because of this, what I would suggest is that if you're pooling your non-mandatory reserves, you put it in the pool for non-mandatory so that you've got that money available and you can use it for that purpose, or the members might have the right to, you know, basically either waive those reserves because you've got enough money in there for all of the items in the pool, or potentially use it for another purpose with a member vote. Because generally speaking, keep in mind, these reserves can't be used for any purpose other than the assets that are in the reserve pool if you've got a pool, or that specific asset if you're using a straight line method. The reserve study may recommend that reserves or replacement costs don't need to be made. Like I said, if it's going to be more than 25 years before you need to incur that expense. So in a budget, this is where we get into mandatory reserves. If a budget adopted by an association that's required to obtain this structural integrity reserve study, reserves must be maintained in full For the items identified in section 718.112 little g is what we call it. So we call these either SIRS reserves, mandatory reserves, or little g reserves. If the association is responsible for these items pursuant to the declaration, the reserve for any of these items must be based on the findings and recommendations of the most recent structural integrity reserve study. We call that a SIRS just to make it easier. But the bottom line is you must go by what's in that reserve study. If you don't like what's in there, you can get another one done at an additional expense, but you can't just ignore it. Now, here's the list of items that the Florida legislature considers important enough to require. If it's something that the association is obligated to maintain, you're going to have to reserve for these items. The structural integrity reserve study needs to be completed at least every 10 years after the creation of each building on condo property that's 3 stories or higher, as determined by the Florida Building Code. So the same buildings that were subject to the Milestone inspection report will generally be the same ones that are obligated to comply with this structural integrity reserve study requirement. Okay, the study needs to include at a minimum these items that are listed in this slide. Now, the reason that I'm not talking about it in detail, look at letter H. It's, again, anything with a deferred maintenance expense or replacement cost that exceeds 10 grand. We talked about this earlier. Here's the distinction. And the failure to replace or maintain that item negatively affects the items listed above, meaning the structural components of the building, as determined by the visual inspection portion of the structural integrity reserve study. So in other words, you're already required to reserve anything that's going to cost more than 10 grand in deferred maintenance or replacement cost. Now it's a mandatory fully funded reserve starting, I believe it's December 31st, 2024, for any budget that's adopted on or before that date. You need to fully fund your reserves for anything that impacts the structural integrity of the building and costs $10,000 or more, or I'm sorry, costs more than $10,000 to do that deferred maintenance or replacement. Okay, at a minimum, here's what needs to go into the study. And candidly, this is mostly for your information because the study is probably going to contain these items if you use someone that's qualified to perform it. There are several exemptions to needing this study performed. If you don't need it, you don't need it. You might get it anyway to make sure that your building is safe. Buildings that are less than 3 stories in height don't need it. A single family, 2 family, or 3 family dwelling with 3 or fewer habitable stories above ground, which is distinct from that first item here, doesn't need a structural integrity reserve study. Neither does any portion or component of a building that hasn't been submitted to the condo form of ownership. So this is a slight distinction here. Okay, we're talking about the structural integrity reserve study doesn't apply to the portions that haven't been submitted to condo ownership or co-op ownership. And anything that is maintained by someone other than the association that's still part of the building. Finally, again, commercial condominiums have no obligation to do this. The presumption there is that people aren't residing in a commercial condominium. Why there's a distinction? I mean, I obviously want to make it easier for commercial condos to operate, especially since we represent several, but people are still spending, I don't know, 9-10 hours a day in a commercial condo if they're working there, or, you know, depending on the time frame of operation of that business. I don't know that it's any safer just because people aren't residing there. But bottom line, commercial condos, this does not apply. Who can perform this? The structural integrity reserve study can be performed by any person qualified to perform it. The visual inspection portion needs to be performed by an engineer, architect, or a person certified as a reserve specialist or professional reserve analyst by CAI or the Association of Professional Reserve Analysts. So this is a distinction between the Milestone inspection report, who can do it, versus the SIRS. Okay, this is going to be only an engineer and architect, which also applies, or a person certified as a reserve specialist or professional reserve analyst, rather than some team that is operating under an architect or engineer. So they are distinct. Make sure that whoever's doing this has that qualification. Deadline to complete it. Associations existing on or before July 1st, 2022, which are unit owner controlled, need to have this done by the end of this year for every building that's subject to it. If you are required to complete the milestone inspection on or before December, 31st, 2026, you can do these together to save money if the same company is willing and capable of doing both simultaneously. There's nothing that says you can't do them together. Now, this is a distinction. Even if you would otherwise be required to do the SIRS sooner, and you only need to do the milestone inspection report by the end of 2026, you can do them together. Don't presume that everyone can do them together. Annual updating, the association can adjust for inflation like we talked about earlier. And what else pertaining to this structural integrity reserve study? One of the most important things that came out of this is, well, one of many important things that came out of this legislation is that you can't waive all of your reserves, and that the member vote for waiving reserves or reducing reserves is higher if you are waiving non-mandatory reserves. So we talked about SIRS reserves, those are the mandatory ones. Those must be fully funded if for any budget adopted on or after December 31st, 2024. Okay, the members of a unit owner controlled or association can, by majority vote of all of the members, reduce or waive reserves for non-SIRS reserves. Okay, that is only for the items that are not mandatory under the statute. The SIRS reserves cannot be waived, cannot be reduced, must be fully funded for any budget adopted on or after December 31st, 2024. Okay, you can't determine to provide no reserves or less reserves than required by the statute for the little g items. But for a multi-condo, and we'll get into that in a second, what that means, you can reduce if an alternative funding method has been approved by the division. It's not just, well, we can do it because we're a multi-condo that qualifies for this. It's that funding method needs to have been approved by the division. This is a Florida entity. It's a governmental entity. Okay, we're talking about a method approved by the division for funding capital expenditures and deferred maintenance obligations under the SIRS for a multi-condominium association operating at least 25 condos, meaning you have 25 condo buildings that are operating separately and are expected to fully satisfy the association's reserve funding obligations by the allocating funds in the operating budget. In other words, you're funding it through your regular assessments rather than as part of your reserves, which are part of your regular assessments. So it's basically a different portion of the budget. You're still funding it fully. You're just doing it in a different way. Okay, using reserves for a different purpose, same thing. Okay, it's the same mandatory versus non-mandatory, which we talked about a minute ago. So I won't go through it again, but just understand you've got the same options to use those funds that have been put into the reserve for a different purpose. You can't do it at all for little g reserves, the SIRS reserves. You can do it with a majority vote of the entire membership, not just the people that show up at your meeting, but your entire membership for the non-little g items. Okay, pulling of anything other than little g items is totally acceptable. There is some question whether pulling of the mandatory reserves. Do not mix your non-G reserves with your G reserves, your SIRS reserves with your non-SIRS reserves. Okay, you can have at a minimum, regardless of what your attorney is looking into, you need two separate pools. One is the non-statutory reserves. The other one is the statutory SIRS reserves. There is a question because the Florida statute is not entirely clear on this issue. My opinion is you'd be taking a risk if you try and pull your SIRS reserves rather than doing straight line reserves. It will cost you significantly less every year that you'll be putting away, or that it'll cost your members significantly less in assessments. But check with your legal counsel to make a determination. And frankly, my recommendation is to get a written opinion from counsel as to whether you can pull, if this is something you want to do, pull your SIRS reserves. It's a major issue going on in the Florida condo community right now as to whether this is allowed or not. The DBPR hasn't clarified really after the statute changed last year. We don't see a clarification coming up this year. So it is something that you really need to check with your attorney about. And anyway, moving forward, maintenance of common elements is the responsibility of the association, except for maintenance responsibility for limited common elements assigned to the unit owners. The association must provide for maintenance, repair, and replacement of condo property for which it bears responsibility. After turnover, this is basically developer issues, just to clarify. After turnover control to the association, of the association to the unit owners, the association must perform the maintenance identified by the developer until the association gets new maintenance protocols from a licensed professional engineer or architect or a reserve specialist or professional reserve analyst. What does this mean in plain English? After turnover happens, after the members take control of the board, you have to have any work done that the developer told you, hey, this could be a problem if you don't get the work done. That doesn't mean you can't still go after them for a construction defect if this is their fault, okay? But you'll want to talk to counsel about what this means for your particular condominium. If you're getting ready to turn over or you've recently turned over. And when I say recently, I mean within the last year or two. If you've gone beyond that, you might be out of time to claim that there was responsibility of the developer, but talk to your attorney about that, and specifically talk to an attorney that's well-versed not only in condominium law, but also in construction law. We have someone that's board certified in that area of law, and frankly, rather than take that issue on myself, I always try to bring him in to give a more detailed analysis of what the law says about the specific situation the association's working with. Disputes regarding the milestone inspection and structural integrity reserve study. Dispute basically means, in this instance, that the association's not doing what it's supposed to do. You either didn't get the inspection done, you didn't produce the report, the inspection is taking too long, etc. Or you're not doing the work that's required because you don't have the money. Any of those issues that are described in this slide are now going to go to pre-suit mediation as one option, pre-suit non-binding arbitration, or pre-suit binding arbitration. Whoever is sending the demand has the option of choosing one of those three as of right now. My recommendation is always going to go to mediation, try and get it settled, and then let a judge decide the issue. There were some excellent arbitrators. There are still a few excellent arbitrators that are working with the DBPR, but this is going to a government entity who has not necessarily been consistent over the last few years in following precedent, in knowing the specific areas of law that are being discussed in the arbitration. The judge won't know the law necessarily either, but the judge is easier to appeal when a bad legal decision is made, in my opinion. And also, why pre-litigate? Why not just try and get it settled and then go into litigation? So that's why I recommend mediation whenever you have those three options. And that applies to covenant enforcement and several other issues as well, that you have those three options. That's what section 718.1255 talks about, is pre-suit disputes and how those get resolved in a condo. The same thing, by the way, applies to co-ops. The co-op statute just refers back to this statute. Moving forward, owner disclosure requirements, I'm not going to get into, because frankly, those are specific to the owners who are selling property, and these are their responsibility, not the association's responsibility. And then we have developer turnover requirements. If they've gotten a structural integrity reserve study done, they need to produce that as part of the turnover. So they need to produce it as part of the documents that they hand over. The developer generally won't need to have a SIRS, because I don't know of many communities that take long enough to develop that that's going to be an issue here. But there is a turnover inspection report that is now required, and the statute clarifies what that needs to entail. It's not the same as the SIRS study. So here is a breakdown of what goes into that developer turnover report. Again, it's going to be an inspection of many of the same items that would go into the SIRS, but it's not going to be everything. You'll note that there are some things in here that are not actually in the SIRS. But the glaring deficiency here, the thing that's not included in what the developer needs to turn over to the association, is that catch-all of anything that is going to cost more than $10,000 to repair. So the bottom line there that I will kind of end with today is, don't just rely on that. That's something that the developer had done, paying someone that constantly does these probably for the developer. It's not going to include everything you need to know about your building. I would still suggest hiring an engineer, architect, or someone else to go out and inspect the building the second that turnover is completed and you have the ability to do it, because that's where you're going to find a lot of your deficiencies, a lot of your construction defects. And frankly, you should be holding the developer accountable for any of those defects that occurred, rather than basically giving up that right by not having an inspection done for 5 to 10 years after the turnover happened. Keep in mind, you only have 7 years from the date of the certificate of occupancy now to file a claim for a construction defect. So if the CO was issued and the developer waited 5 years to turn over, that means you've got maybe 2 years left. So I'm not suggesting that every developer is going to screw this up. Most do not, candidly. But you want to know the answer to whether they did or not before it's too late to do anything about it. It's 12:40. We've got like 5 minutes left. And I appreciate everyone being here today. I'm going to go ahead and turn it back over to Jim and Rachel for some closing thoughts before we turn it back over to Jeff to clarify how you can fill out all of your surveys, as he mentioned earlier, and get any certificates you might need from this class. So now it's my turn to shut up and take another sip. Rachel, Jim, thank you so much for having us here today. It's really a pleasure working with you guys. I really appreciate the substantive additions that you've made to what I'm capable of explaining. And I'm going to go ahead and take a sip of water. Thank you again. I'll leave it to you.
Thank you so much, Alan. This is really great information, a very good overview. So we appreciate all the legal aspect. We will always leave that to you, and we'll get down into the nitty-gritty of the construction side of it. I just wanted to mention we do have a course available for CE credit if anybody is interested. We have a much briefer overview of SIRS and Milestone in there, but it really digs into, once you go beyond that, when you're preparing your reserves, when you're looking at any potential capital improvement projects or repairs, how to really make sure that you are looking at the community correctly to address any moisture or water intrusion issues, as well as how to prepare those bids, sort through vendor bids and applications and things like that. So I won't spend too much time on that, but if you're interested, feel free to email me or visit our website. I know we didn't get to get into all of your questions in the chat today, so if you have any specific questions, please feel free to email us. We do want to hear from you and get as many of your questions answered as we can. So thank you, Alan and Jeff.
Yeah, and I'll say the same for the legal questions. Please do feel welcome to email me. I apologize that there was just a lot to cover today and we just didn't get to them, but I do want to answer your questions. So for the practical, how does this work questions, feel free to reach out to Rachel and Jim. For the legal ones, feel free to reach out to me. And to the extent that you get it wrong and send it to the wrong person, I'm sure they'll have no problem sending over to me if they're not going to answer, and I'll do the same.
Thank you very
Jim.
much for allowing us to do this today. If you have any questions regarding reserve studies or waterproofing, especially when it comes to vendor evaluation, to make sure you're getting good bang for your buck, feel free to reach out to us, and either myself or Rachel will respond. Thank you again.